Hello, everybody. In this week's video lecture, we're going to cover civil liberties from Chapter 4. And I want to clarify before we start, this chapter covers civil liberties. So the next chapter, Chapter 5, is going to cover civil rights. So let's make sure that we have identified and clarified what the difference between the civil liberties and civil rights are. Civil liberties are the limitations on government's ability to interfere with an individual. Okay. Liberties are limits on government power. So we have areas in the Constitution that are protected from government interference, or the easiest way maybe to remember is protection from government taking action against you. Civil rights, on the other hand, is the obligation of government to take a positive action, to do something. So a right is something the government does for you. Liberty is something the government is limited from doing to you. So we're going to be talking about civil liberties for this week. There are some rights, actually. Don't let the term rights confuse you right now. There are some rights, very few actually, that are contained in the actual body of the Constitution. And we would really probably term them as civil liberties. They're not found in the Bill of Rights. They're in the actual body of the Constitution. In Article 1, Section 9, those rights include the right to habeas corpus, bring the body, or bills of attainder, and ex post facto laws. There's also some to be found in Article 3, but again, these are rights that are guaranteed in the Constitution itself and not in the Bill of Rights. What we're going to cover today are going to be liberties that are contained in the actual Bill of Rights. And if you've watched some of the other video that is in this week's lesson, they were never named the Bill of Rights. That's just a colloquial term that we have developed over time, is calling them a Bill of Rights. So the Constitutional Convention ended without this document or a Bill of Rights. Federalists, led by Alexander Hamilton, who argued that a Bill of Rights was not necessary, said that the national government only had delegated very specific stated power. And when I say delegated, I mean the people delegated that power to the government. So the national government could only do what the people said it could. Hamilton said, this is a great quote, "For why declare these things shall not be done, which there is no power to do?" Well, that wasn't good enough for the anti-federalists. They saw a potential abuse for government power absent this spelled out Bill of Rights, and they really advocated and fought for these Bill of Rights. The Federalists eventually, I would say in somewhat of a type of a compromise, agreed. And in an effort to calm the fears of the anti-federalists, agreed to develop a Bill of Rights. So James Madison, interesting, who's I consider him to be the father of the Bill of Rights. James Madison, in his very first term, because he was elected in the very first term in session in the House of Representatives, he introduced 17 amendments to the Constitution, which were passed and sent to the Senate, who adopted 12. They kind of compiled some of those 17, so there's multiple protections in some of these amendments, okay? But ultimately, the states ratified 10 of those 12, and these 10 amendments are what we call today the Bill of Rights. And they really deal with the private sphere of personal liberties, limits on government. And we have enshrined those. And frequently when people talk about the Constitution, they're actually referring to the Bill of Rights. There are two dimensions of civil liberties. Okay, this is a little bit complicated, so stay with me. There are two dimensions of civil liberties. One is called substantive, the other is procedural. Substantive limits what the government can and cannot do. Okay, the substance of it. So, for example, the government cannot establish an official religion. It can't seize private property without compensating for just compensation, and that people have a right to due process. Okay. So when we've talked earlier about fairness and justice in government, this is what we're talking about. So we want to make sure that in the procedural part of the law, we're talking about policies and procedures that the government has to follow when it's acting against us. So you've got substantive, what is a substance? And you've got due process or procedural, what are the process and procedures in place? This table is in your book as well. Take a look. I suggest that you review this table and become familiar with it. It sets out the different categories of rights and what amendments are attached to those particular categories. Civil liberties are really important. So that's what allows a minority to speak and act as they desire. Okay. But remember, as we'll get into this, there are limits. These are not limitless. And we'll talk about some of those particular limits. So why are these civil liberties so important? Okay. Again, they allow the minority to speak and act as they desire, recognizing, of course, that there are limits, but they also serve as a national means to protect a marketplace of ideas. We'll talk about that. For a healthy democracy, we need to allow people to live according to their preferences, the freedom of their belief of thought. So there are some limits, but we're going to talk about the nationalizing of Bill of Rights. And when did they really start to have a broad influence across the states? Because they didn't start out that way. In 1833, less than 45 years from when the Bill of Rights were actually introduced, and before the Civil War has ever happened, the Supreme Court ruled in a really important Supreme Court case, Barron v. Baltimore, okay, that the Bill of Rights only applied to the national government. It did not apply to states. Okay, in other words, the Bill of Rights only limited the power of the national government, not the states. Most states already had a Bill of Rights that limited state power, but the Supreme Court in Barron v. Baltimore said that the Bill of Rights only applied to the national government. Well, we have a civil war. And right after the Civil War ends, 3 years in 1868, we see some major changes because of the 14th Amendment. And the 14th Amendment is a significant change to the Constitution. It's very important. Some say it is the most important amendment to the Constitution. I agree. The 14th Amendment implies that the Bill of Rights applies to the states. That's what it says, okay? That the 14th Amendment says that the Bill of Rights now applies to the states. However, Supreme Court didn't necessarily agree with that. They still were under Barron v. Baltimore. So it took seriously almost 100 years for the Supreme Court to come back and start to apply the majority of the Bill of Rights to the states. In 1897, the Supreme Court ruled that due process clause, okay, that the government has to follow established procedures and processes, okay. So in 1897, the Supreme Court stated that the 14th Amendment applied to states, but it didn't just come back and go, okay, all of those 10 amendments now apply to the states all at one time. That's not how it happened. It came into by a process that we call selective incorporation. They selectively took parts of the Bill of Rights and applied them to the states, and now the states had to follow them. Okay, so this public use of property, okay, for compensation, and in 1925 in Gitlow versus New York, freedom of speech, that the right to freedom of speech wasn't actually applied to the states until 1925. Okay, so that was in Gitlow v. New York. freedom of speech was ruled to be among what we would consider fundamental. So as we go through and you think about what are the most fundamental rights that we have as a human being, what is our most basic rights? Okay. Speech is considered one of those most basic rights that we have as a person. And it's also protected, that the due process clause is one of our fundamental rights. Okay. But there was some expansion on these liberties, basically due to Supreme Court decisions. So in this important case, Palco versus Connecticut, the court ruled that double jeopardy, many of you are familiar with what double jeopardy is, and that's this idea that you can't be tried for the same crime twice. Not in a lot of state constitutions. So they came back and incorporated it into the Bill of Rights that states now have to follow double jeopardy if it's in the same court. Okay. It's really important to remember selective incorporation. I am just telling you, you need to understand it and be able to explain it. It put limits on the powers of state governments. Okay. So again, the Bill of Rights does not suddenly across the board apply. They're applying them one at a time. And so double jeopardy becomes an applied right. After 1961, most of what we would consider the most important provisions of the Bill of Rights actually were selectively incorporated by the 14th Amendment, and they are now applied to states today. Okay. Interestingly, the Third and Seventh Amendments still have not been applied to the states. I don't know that states need to worry about not quartering soldiers, but basically almost every state has voluntarily complied with the Seventh Amendment, so that has not had to be incorporated. The requirement of jury trials specifically, states are allowed to set up their own jury trial system. However, they can take emergency actions as long as they aren't prohibited by their state constitution or their federal constitution. So states can retain ability to restrict some individual freedoms, but they can't violate our U.S. Bill of Rights in that process. This is another really great table that gives you a recap of when each of the individual clauses or provisions of the Bill of Rights were selectively incorporated. Okay. I think it's also important to note that the Bill of Rights are not, number one, they thought the First Amendment was the most important, and number two, they thought it was the second most important. That's not how it worked. It just is how they randomly broke down. There was no specific order or where they said this is the most important, so we're going to make it number one, and this is number two, and this is number three. This is just how they ended up being in the final document. The First Amendment has multiple clauses. Okay, there's 5. So we'll start with freedom of religion. The amendment says Congress shall make no law establishing or prohibiting the free exercise. So we've got there's 2 things in the freedom of religion. Okay. So the government cannot impose or require any particular religion. Okay. It's a reference. Some frequently reference it to a wall of separation of church and state. Okay. That quote actually comes from a letter written by Thomas Jefferson. It's not in the document, but some think that that's a reference to that concept that there should be some sort of a wall, but it is the government can't establish a specific religion. The next is free exercise clause, and this is the freedom to practice religion of your choice without state interference and the ability, this is important, not only does it allow you the ability to practice a religion of your choice, it also allows you to not practice a religion. I would suggest that's your freedom to believe. The Establishment Clause had some different interpretations over the years. Well, you can't establish an official church. important to note that it also reflects the majority of the authors of the First Amendment. They had some religion issues that were significant. States actually had required religions, so that the idea that government can't favor one religion over another. And when we look at this, that's like saying it's not prohibited. They're not prohibited from providing some level of support to religious institutions. But if you're going to provide support to one religious institution, it has to be equal. You cannot show favoritism to any one particular group over another. The third interpretation is that there must be this wall of separation of church and state. This is just a view. I'm not saying that I agree, disagree, or whatever. It's just these are different views. That the government can't breach that wall. Okay, that's taken a pretty hard view. There's a disagreement, however, over let's say, how high is that wall, or what that wall actually is, or what it looks like. And we've seen some of those cases come up lately. Prayer in schools, I'm talking K-12 schools, like high schools. That is a hot area. And if you followed, there was that case in Bremerton, Washington, where that football coach would pray in the middle of the field, and he was terminated, and he took his case, and it was eventually heard by the Supreme Court. And I'll be honest, the Supreme Court cherry-picked some of the facts and ignored some of the other facts. But that coach was reinstated for his ability to practice his religion. By the way, though, as soon as he got his job back, he quit. But it was under this guise of freedom of religion that he should be able to say that prayer. We've had lots of cases in the public arena about the Ten Commandments. I think you're going to see more of those coming up soon. But the court has essentially said, in a kind of confusing and contradictory cases, because in one case they say this, in another case they say that. So it's difficult, but they say if it's a secular or a non-religious purpose, it's okay to have the Ten Commandments up. But if it's for a religious purpose, you can't. So you can see it's confusing. But these decisions tend to be a little bit all over the place. It's okay to be confused because it's challenging to decide, which is why I think we're going to continue to see these cases come before the Supreme Court. There are some limits. Okay, so we're talking about the free exercise clause. It allows your right to practice a religion of your choice. You're not required to practice religion. It protects the rights to be a non-believer. In the case of West Virginia State Board via Barnett, the Supreme Court had, before this case, before the Barnett case, they came back and said that children that were Jehovah's Witnesses had to do the Pledge of Allegiance. Look at the date here. So you can see we've got some World War II stuff going on. But they came back and said Jehovah's Witness kids had to stand up and do the Pledge of Allegiance, which violated their religious beliefs. So in this West Virginia v. Barnett, the Supreme Court actually overturned their previous ruling and said we cannot force people to do something that violates their religious views. So they came back and upheld the rights for these Jehovah's Witness school children. If you looked at some information that I put on this week's reading about an oath in Idaho, you know that you can't just do anything though. So this is one of those rights of practicing your religion. It's not unlimited, okay? You can't do human sacrifices. That's actually been a Supreme Court case. You can't use illicit or illegal drugs. That is not protected. You obviously cannot practice polygamy or bigamy as part of your religion. So it protects your right to also be a non-believer. You can believe as you want. Doesn't mean you necessarily get to practice it, but I would say generally your ability to practice your religion as you want is protected. Let's see, I'm just thinking, there's some other cases coming up that have happened. In 2014, the court ruled in Burwell versus Hobby Lobby that the government can't force a business owner that's very, very religious to provide insurance benefits for birth control because that particular owner of that business is opposed to birth control or whatever those insurance benefits were. So those are limited. That is not an unlimited right. Okay, let's move on to another clause in the First Amendment. Okay, the freedom of press and the speech. So I'm really probably going to get more into speech here for a minute. So Congress shall make no law abridging the freedom of speech or the press. So when I talked about a marketplace of ideas, if we can't speak, if we can't read, if we can't share this marketplace of ideas, do we really have a democracy? So in 1938, the Supreme Court ruled that legislation that had been passed, now remember, 1938, we're right before World War II, that restricts freedom of speech actually got, this is an interesting concept, that they actually would get what's called strict scrutiny. Okay, scrutiny. Think about how do we scrutinize or look at something? So they considered the freedom of speech something that would get really strict scrutiny, super close attention by the Supreme Court, okay, and how they would look at this case. So they got the highest standard of judicial review, the court looking at this case about whether the government, and I said government, not Facebook, not social media posts or whatever groups out there, we're saying the government has to have a really, really good reason to restrict your speech, to not allow it. Private businesses are not government. They can have different requirements regarding the freedom. Freedom of speech applies to government, not other private entities. The most protected speech is political speech. That gets the highest scrutiny, okay? And courts have to have a compelling, meaning a very, very good reason if they're going to limit political speech, okay? The idea is that we want to protect actions that express political ideas. We have things like, they've even came to the point where they say that a financial contribution is actually protected speech. We may talk about that later. I don't know if you agree or disagree, but it's an interesting concept, is money speech. Political speech is protected unless it's going to cause immediate harm. You've probably heard, you can't yell fire in a crowded theater. You can't put people's lives at risk with your speech. You can't go in a neighborhood. You can't go in a courtroom and create a big scene and think that that's protected. That is not protected speech. Symbolic speech can also be political, but symbolic means it's not really actual use of words and speaking. It is an action designed to send a political message. Okay, we may not necessarily like some of the symbolic speech that we see happening. For example, flag burning. We may not like it. We may so strongly disagree with it, but it is considered a strong political statement. So it was determined to be constitutional. You can't destroy other people's property, but if you burn a flag, it's not against the law. These peaceful actions are protected under the First Amendment. So we have activities like picketing, peaceful demonstrations. We may not necessarily agree or like with what's happening, but as long as they're peaceful and they follow the law in that process and they get like a permit, or they have permission to be there, or they are in a general public space, that speech is protected. The right to assemble, okay, to come together. I would suggest that also even is part of the religious. It's really hard to have religious free speech if you can't actually come together and share those ideas. So you can see why assembly is so important. But in 1939, in a really important case, the Hague versus the Committee for Industrial Organization, that the government may not prohibit speech for demonstrations. So they, at one point, they came back and they said, wow, that's a demonstration. We're not going to allow it. No, if it's political, generally they are allowed. This is another, wow, this is a really controversial case. I don't know how many of you are familiar with the Westboro Baptist Church. but they were holding protests at military funerals. This is a picture. These were really upsetting. This group was all over college campuses all over the United States, but what really got them attention is this church out of Kansas would come together. They had small children carrying signs. These are these are not their worst signs, I promise you. But what they would do is they would come outside of the funerals of soldiers, and they would protest at these funerals. It happened in Pocatello. It happened in other places in Southeast Idaho. This was extremely distressing for the families of these deceased military funerals. But this was right after 9/11, the war in Iraq and Afghanistan. And so there were quite a few of these military funerals. And the Westboro Baptist Church was sued by the family of a deceased soldier. And the Supreme Court said, it's really, really ugly speech, but it's protected because they were complaining about the U.S. government. If you want to look into the Westboro Baptist Church, it's not comfortable. It's not comfortable to look at. So, fighting words. Fighting words are not protected speech. Okay. So when you go from symbolic to a direct incitement and damaging conduct, we've seen some protests in the last few years about different societal issues. When somebody gets up and they encourage people to go burn places down or to fight or whatever, that is not protected speech. In a case in 1951 in Dennis versus the U.S., the court ruled there is no substantial public interest. Okay. There's no substantial public interest in lewd, obscene, profane, libelous, and fighting words. That is not protected speech. Okay. I'll say it again. Language that is lewd, obscene, profane, libelous, and fighting words. When people say, well, I have a right to, no, you don't. Just, okay. You can quote this case if you need to, Dennis v. U.S. But in that case, the court reversed pretty much every conviction that they used fighting words. So I would say that's a little controversial still, but we're still trying to get this balance of what public safety is versus the right to talk about things that are controversial opinions. We've seen things about people taking a knee, that it's symbolic. People don't like it, but it's still, again, it's symbolic. The hotbed of issues have been college campuses. They will invite controversial speakers to come, and there are such ugly protests and threats on those people that I bumped my slide, that they've had to balance safety against the speakers that have been invited, because you've got to have peace. So sometimes some of these protests, they've been shut down to allow those speakers to speak, because you can't incite violence. But college campuses, watch, I'm just saying, they tend to be real hotbeds of free speech issues. Student speech, high school students in public schools, okay? It's a category all by itself. The rights of students in K-12 public schools is not the same as what's on college campuses. So they have a limited right, okay? High school students specifically, they're the ones that are going to be probably challenging this. That was a really famous case, Tinker versus Des Moines. Look at it, it's right in the middle of the Vietnam War. Students wore black armbands to school to protest the Vietnam War. Actually, I've met Mary Beth Tinker. It was she and her brother that were fighting that particular restriction. She's still a very big advocate for freedom of speech, but the Supreme Court said kids' rights don't end at the schoolhouse gate, and that they could wear their armbands to actually protest the Vietnam War. Okay. But if it's inappropriate language, and there is some great cases out there, but in 2007, there was a case out of Alaska, Morse versus Frederick, where a student went outside and had some other students help him hold up a banner that said "bong hits for Jesus," and he anyway got in a lot of trouble. And his case ended up in front of the Supreme Court, and the Supreme Court ruled eventually against Joseph Frederick, and said that the school could actually ban it. I've seen the banner. It is huge. This isn't some little poster. It was a big banner. You should look up pictures of the bong hits for Jesus. We've got commercial speech, so not as protected as political speech. You can't have false and misleading ads. I mean, the government has to have a pretty rational reason, not strict. It can be a lower level, just a rational reason. And what they found was they were running ads on television, and they started asking young children, and young children could identify the Marlboro Man over Ronald McDonald. And they're like, yeah, this is a problem. You don't see tobacco advertisements on TV like when I was a kid. They also were running ads when I was a kid for something called Geritol, and they would run this. Oh, older people, you have poor, tired blood, and if you take Geritol, so then they'd show this older person taking Geritol, then all of a sudden, like they're incredible, like almost Olympic athletes. And they came back and said, you can't make that claim. That's not accurate. So it basically put Geritol out of business when they came back and said, you can't just do false advertising. So freedom of the press, okay. Freedom of the press is the government can't block publication of material that it seems to be libelous or harmful, especially if it's the truth, okay. It's limited only under very extraordinary circumstances. States also have laws that protect journalistic sources. They want the press to be another set of eyes on government. So if they bring in and they try to get these reporters to testify and reveal their sources, they're generally protected. But you should know there are none of those laws are much more limited at the federal level. Print media, okay. So looking at print media, we talk about libel and slander, okay. So what can the press actually be sued for? Or actually, I would even suggest individuals. So statements that are made in reckless disregard of the truth, okay. Reckless disregard of the truth. If something is just a flat out lie, they can be held responsible for it. When it's spoken, it's called slander. I remember it. Slander is spoken. Libel is written. Some of you may remember that Fox News was sued for $787. Well, they settled for $787 million. It was the Dominion election machine case that just was a short time ago. So yes, if they slander or libel a business and they can show damages, they can be sued for it. This is not done. There's another case pending by Dominion. We'll see how that goes. WikiLeaks is an anonymous community, pretty almost impossible. How are you gonna press, how do you charge WikiLeaks? Online bloggers, really difficult. Try to figure out how to charge them with libel or slander. What do you do about the rise of AI, artificial intelligence, when they use the face of somebody we recognize and they put it on the body of somebody else? Who's going to be held responsible for that? I think there's some really interesting law that's going to come from this, but in the meantime, I think it's challenging. It's challenging. And internet providers have not been held responsible or liable for what people post. but I think individuals have, if well, I know individuals have, if somebody can come back and prove that it caused them harm. Yelp reviews, or different reviews that people put online. I know there can be issues there. So just know what this process is. Okay, all right, let's talk about pornography and obscenity. It's really difficult to define and have everybody agree on what pornography and obscenity is. And I can say that because Supreme Court Justice William Brennan he says, it's speech or writing that appeals to prurient interests. Okay, I can't say what that means. And actually, when he said that, it just created more confusion. It did not help. And then to make matters even worse, in 1964, and I don't mean to smile, Justice Potter, I've got a typo, I apologize. Justice Stuart Potter wrote, he says, I can't define it, but I know it when I see it. Interpret that for yourselves. Okay, so we've got these really vague standards trying to strengthen these restrictions. You may really find this fascinating. People will find ways to get around the law. So these are the standards. One, as a whole, is it prurient? Okay, so look up the word prurient. Is it offensive or awful to the average person? I don't know what the average person is. I don't know that we would all agree what the difference between what is obscene, what's not obscene. Okay. Community standards. Okay. So I can understand that. Las Vegas is certainly not Pocatello or Idaho Falls. Okay. So there's different community standards. Okay. It's sexual conduct that is patently offensive, or it lacks any artistic, political, or scientific value. So this is what people that were producing these pornography films, what they did was they said, oh, wow, well, we can work with this. So what they did was they started to take the videos or films that they were making, and at the end, they would have some actor stand up, wave a flag or have a flag in the background, give a patriotic speech, and then they'd say, okay, well, now there's a political interest in this. Okay. Well, they came back and said, that's not going to work. So that no longer is a protection, but I don't know what we would say community standards are. I don't know if that means your public libraries. Who gets to decide? Is it on the internet? Is it only in print? Okay. What is your community? Is it your city? Is it your state? Is it the nation? I don't know, but it's really difficult. Congress hasn't really came up with it. We know child pornography is off the table no matter what, of course. They tried to pass this Communications Decency Act. That got struck down, that it was a violation of free speech. So just think about, again, what happens with AI. What are we going to do with technology? I would suggest that this is continuing to be a challenging subject. Okay, now we're going to move into some out of the First Amendment. Okay, let's talk about the Second Amendment. It's a little more, I think it's a lot less clauses, a little more straightforward. The right to bear arms. It applies to states and localities, and you cannot ban the possession of a firearm in a home. That was in the Supreme Court case in 2008. The District of Columbia versus Heller, that was out of Washington, D.C. There's been other cases since then. The court continues to expand on gun rights. And that's probably been more so even in the last decade. There was almost nothing before 2008, almost nothing. And since 2008, we've had a handful of really important cases that have been decided. I think we're not done with Second Amendment cases. States can restrict access. They can do waiting periods, registration. what kind of arms people are actually allowed to have. So states still have some say in this, but again, the Supreme Court is weighing in on that on a case-by-case basis. So I would just say that proponents of the Second Amendment right now are being quite successful. Anyway, so it's making it more difficult and more challenging for states to challenge Second Amendment protections. I would suggest that this is an incredibly important amendment. Okay, the Fourth Amendment, very important. Okay, these are generally considered rights of the accused, due process, following established procedures and process. The government has to follow procedures. So they're saying, oh, that person was denied due process, meaning the government didn't follow procedures. Okay, so the government has to follow procedures because it's the right of every citizen to be free of an arbitrary action that can happen at any time. You shouldn't have to guess what the government's going to be doing. So you've got the fourth, fifth, sixth, and eighth. Okay. Fourth, fifth, sixth, and eighth all are the essence of or part of due process. So more on the Fourth Amendment. The right to be secure against unreasonable searches and seizures. Okay. The government cannot have improper searches and seizures. There are some limits on this, but we're not going to get into that right now. But there are things like the exclusionary rule, what can be excluded, the ability of courts to exclude illegally obtained evidence. That's a really important case. So her name was Dalry Mapp. She brought her case, Mapp v. Ohio, claiming that the police had unlawfully searched her house. She was actually quite successful. It's a complicated case, but just for basic understanding that it was a violation of the Fourth Amendment and her rights to search and seizure. Okay. In 2012, the United States versus Jones, the police and the prosecuting attorneys can't attach a GPS to a vehicle to secretly monitor that person. Okay, so basically, you can't put a GPS on a car anymore because who needs to? We all have one of these things, cell phones, so we've just basically gave the government a way to track us. They can ding off those towers. They don't even need to put GPSs on us anymore, so I don't know. They know your phone number, they can find you. This is one of the more popular amendments, the fifth. People plead the fifth. So it's about your Miranda rights. So when we say, read them their rights, we're talking about read their rights under the Miranda rules. So persons who are under arrest, okay, listen to what I'm saying. You have to be under arrest. Your right to liberty is being limited or denied. Okay. So if you're just under questioning, if they're just sitting in a courthouse or in a police station and they're not under arrest, they do not have to be read the Miranda rights. Okay. So they must be informed before a police interrogation if they have been arrested of the right to remain silent, i.e., stop talking. Okay. The right to stop talking and incriminate yourself. The Fifth Amendment also has a right to a grand jury. A grand jury is called when they're trying to determine if there's sufficient evidence for an indictment. Okay, an indictment is a charge that defendant that has to defend against. So if they're saying somebody's been indicted, that means that they're going to have to defend themselves against those charges. Oh, this is fun. Okay, so when you see police officers in movies or TV shows and they're arresting somebody and they got persons pushed up against the building of their car, and one of them's handcuffing them and the other one pulls the card out of their pocket or wallet or whatever, the officer's reading that card to read them their rights. So they make sure that they get those rights accurate. Okay. They want to make sure, and they frequently have these cards in multiple languages because that matters too. So you have a right to not incriminate yourself. Okay. If I may, I hear lots and lots of people talk about their First Amendment right to keep talking. And I'm going to I'm going to remind you that people have a Fifth Amendment right to stop talking, to just shut up. So I want people to remember you may have a First Amendment right to speak, but maybe more importantly, you have a First Amendment or a Fifth Amendment right to not speak. Double jeopardy, that means you can't be tried twice for the same crime in the same court system. So you could have a case in a state court and then in a federal court. That's not double jeopardy. Okay. Eminent domain, the takings clause. The government can take, basically purchase private property, force you to sell, but they have to show that they have a public purpose for doing it, and they have to give them fair market value for that property. That is a pretty controversial part of the Fifth Amendment, and it's also in Idaho's Constitution. Okay, the Sixth Amendment provides a right to an attorney, and that's a case of Gideon versus Wainwright. Great case. 1963. If you are going to go to prison, have your freedom restricted, your liberty restricted, that you should have a right to an attorney. And if you can't afford one will be defended for you. So it also talks about your right to have a speedy trial and that you have a right to confront witnesses in front of a jury or a judge. The Eighth Amendment says no excessive bail, excessive fines, or cruel and unusual punishment. We could talk about the death penalty. It's been argued that it's cruel and unusual. The court has not, it's not currently buying that argument. At one point they did, but that's been overturned. So now we're back. I mean, they've wavered on it, but not for at least 50 years. That hasn't been an issue. It's currently considered constitutional. It's allowed, but they have to follow, remember, due process. There's a process and procedure in place if you're going to consider the death penalty or the death penalty is going to be administered. They have to follow procedures. The states decide whether they're going to have the death penalty in their state. The federal government right now cannot force states to do the death penalty. States generally are allowed to determine what their execution method is, but that method cannot be considered cruel, unusual. A guillotine, a garrote, all of those things are considered cruel and unusual. They used to do things like it was called being torn asunder, which was, tying two arms and legs to a horse and then, smacking the horse and you'd be torn asunder. Not constitutional. It's a violation of the Eighth Amendment. And let's talk about a right to privacy. This is going to wrap these up. The right to privacy. It is not written in the Constitution. I think maybe the framers, the authors of the Bill of Rights said, it's so obvious we don't have to write it down. I would suggest it's certainly a topic of discussion, but it is considered to be part of the third. You can't have soldiers in your house. That's a privacy issue. Fourth, reasonable search and seizures. Fifth, right not to incriminate yourself. Okay. So all of those are considered a right to privacy, and then they're all kind of facilitated under the Ninth Amendment. Any rights that aren't included are considered rights that you have. So that language was used. It was considered under the penumbra or an umbrella of rights. It wasn't specifically stated, but those issues cover some really controversial topics, especially today, in our lives today, that, when does somebody have and not have a right to privacy? Okay, so just got some fun slides here for you. We're going to pick up more on these topics next week, hit more of what the government needs to do. In the meantime, take care, and I look forward to talking to you soon.